The Bill of Rights is in the federal Constitution. The first 10 amendments to the Constitution are called the Bill of Rights. Since 1833, in a decision by Chief Justice John Marshall in a case called Barron versus Baltimore, the Supreme Court had said that those rights in the first 8 amendments to the United States Constitution only apply to the federal government. They don't apply to state or local governments. Barron versus Baltimore is an interesting case having to do with a person who owned a wharf in Baltimore. And Baltimore had a public works project that was essentially depositing silt and other debris into where the wharf was, and it essentially made it unusable. This man named Barron ended up suing the city, saying you had taken my property without due process. And Justice Marshall ended up saying, you don't have a claim under the federal Constitution because the federal Constitution only applies to the federal government. Now, what incorporation did is change things with the 14th Amendment. So the 14th Amendment is enacted after Reconstruction in 1868, and it contains in Section 1 two important clauses, one having to do with the privileges or immunities of citizenship, and the other having to do with due process. Beginning around the beginning of the 20th century, depending on how you count and what you count in terms of the cases, the Supreme Court of the United States began to think that maybe the Bill of Rights actually applies beyond just the federal government, but also applies to state governments and local governments. And so they began selectively to take portions of the Bill of Rights and incorporate them through the 14th Amendment to apply to state and local actors. So now, for example, today, the First Amendment not only binds somebody like Congress or the president, but the First Amendment also binds the governor of your state, your local library board, your local county sheriff. That's what incorporation does.